Well, joining us for reaction on the outcome is Mametlwe Sebei from Unisa's Department of Jurisprudence. Good afternoon yet again, Mametlwe. Just firstly, your reaction to that court outcome.
Frankly, it is not surprising, because let's remember that the direct access to the Constitutional Court, it is regulated by Section 167 of the Constitution that says it's only exceptional circumstances where the interest of justice, and obviously with leave from Constitutional Court itself, can the party approach the Constitutional Court as a court of first instance. And I think the question here should be, does those circumstances exist? And that has got to be looked, firstly, in terms of the substance of the issues, but also in terms of the process. And I think in this of particular importance in this matter, it is a fact that there is no reason to believe that High Court would not have granted MK the interdict it required if it met all the thresholds and the standards to satisfy the court that that interdict actually is due in the matter.
Now, in the absence of the reasons, I suppose to a certain extent, we can just trace back and look at some of the arguments that were put forward by President Cyril Ramaphosa's team, in particular Advocate Kate Hofmeyr yesterday, because when quizzed on the exclusive jurisdiction, she went on to state that beyond the other reasons that you also state is that it's quite limiting to go to the court of last instance in this respect, because what you would want is judicial refinement, and that she argued that the lower courts allow for the opportunity to opine. They get to opine on such weighty issues before they make their way to the ConCourt. But we heard Advocate Dali Mpofu saying, well, for him at least, by the time it gets to the ConCourt, there might be no country. What did you make of just that exchange?
I mean, it's outrageous, I'm going to say, because, I mean, the reality is members of cabinet serves at the pleasure of the president, and in many ways, that power is already implied, in my opinion. And I think as somebody who does hold a brief for the president, for the minister of the police, I think people knows my views on this particular matter. In other capacities, I do think there's a problem with policing in this country. I do think there's a problem with political interference, and the fact that SABC is unable to touch its responsibility to the working class and the working class and the ordinary country. However, the point here is this, that the president has the minister on special leave. Now, whether that power is implied by the power to appoint and fire, we can all debate that. But to say that the fate of the country hangs on that particular issue, when the main problem, the substantial problem, at least for now, has been addressed, which is to say there must be investigation on the allegations of Mkhwanazi. And the person that is a subject of that investigation is his boss, must not be acting in that capacity pending investigation. That issue has been addressed. And what then the lower court, in this case, the higher court, will be able to do, would allow the parties to ventilate the issues on the basis of the facts, but also the constitutional principle, so that as and when the matter finally reaches the Constitutional Court, it can be interpreted strictly on the constitutional principles that are involved, and bring the finality, because this court obviously is responsible for a most authoritative jurisprudence in the interpretation of the Constitution, and it must have the benefit of the opinions of the lower courts, which have the resources allow for a very prolonged trial and massive amount of facts that can be brought there, and the matter be dealt with the kind of thoroughness that the court, which only has one seat and a limited amount of judges, will otherwise be with.
Now, granted, a decision has been taken, but again, when we look at Advocate Dali Mpofu's argument yesterday, he had, among others, when asked around the exclusive jurisdiction, stated that it was a matter that was quite urgent, of national importance because many South Africans are concerned about their safety. But beyond that, he was of the view that there was a constitutional question that had to be answered around the conduct of the president. But when we heard Advocate Kate Hofmeyr, she went on to say it's not the conduct of the president that must be dealt with here, but probably in the High Court. What must be dealt with in the Apex Court would be the obligations of the president that he would fail to fulfill. What did you make of just that exchange?
So let's deal with the interest of South Africans. The allegations that SAPS is a criminal enterprise are concerning, are damning, and there is in reality a merit to it, because when you ask ordinary working class people what is experience the SAPS, from ordinary roadblocks, extortion, robbery, all those things and so on, the cases of impunity for the elite, the corporations, powerful people that are connected, cases being made to disappear, units that are supposed to be pursuing crimes and, of course, offenses against ordinary people by powerful interests in society. All of that are not being investigated, all of that are not being dealt with, and of course, that is legitimate. But I think we've got to be clear. There is nothing in the application that is brought by the NK that is going to be able to address that. The question that is before this court is whether, the minister as a political head of the SAPS should be remaining in that position when they are investigating that regard to his personal conduct,
Yes.
And I think the list of absence addresses that question. Now, whether anything substantial and meaningful will come out of the commission, that is a different issue. But I think Mpofu is exaggerating what this court, even if he was to be granted the order actually it addressed. But I think insofar as the issues of what issues are also involved. I mean, firstly, there is nothing in the Constitution that says higher courts are not having a jurisdiction to dealing with constitutional matters, And it is only saying that the constitutional court is a final and ultimate authority in the interpretation of the Constitution. So they can go the higher court. What in terms of the process is best placed to grant an interdict on an urgent basis in the court, but also that it can apply it bind to the Constitution and come to a judgment. And if there is a question and a doubt on that, that finality and clarity will be brought by the court. That is a structure of the judicial system in this country as espoused in the Constitution.
All right, Mametlwe, thank you very much for your time this afternoon. That's Mametlwe Sebei. He's from Unisa's Department of Jurisprudence. Well, we'll continue to bring you reaction to the decision by the ConCourt not granting direct access to the applicants, that's Mkhwanazi's party, and former President Jacob Zuma in that matter pertaining to President Cyril Ramaphosa's decision to, among others, place Minister Senzo Mchunu on leave of absence.